Hello and welcome to this breaking kind of news in the Karen Reed case. Because apparently, a fourth juror has now stepped forward and confirmed what we heard from both Yannetti and Jackson the other day. Remember, Jackson had direct contact with a juror claiming they acquitted on count one and three. They were hung on count two. Yannetti had a person who knew a juror come forward and say the exact same thing. But now we have this filing that's been filed today by defendant Karen Reed's supplemental memorandum in support of her motion to dismiss. As reflected in the attached affidavit of Alan Jackson, a fourth deliberating juror has now confirmed that the jury reached not guilty verdicts on count one and three. Alan Jackson affidavit blah. Once they were dismissed, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count one and three? No one ever asked about those counts. Juror D told counsel part of her discomfort was that she knew that the jury had reached verdicts on two counts and Karen Reed might be retried on those two counts, and that's just not right. Juror D further stated, every one of us will agree and acknowledge that we found Karen Reed not guilty on counts one and three, because that's what happened. Based on the attached affidavit and all of the reasons set forth in the opening motion and the facts that this disclosure of Juror D completely confirmed the veracity of the previous filed affidavits regarding jurors A, B, and C, the defense respectfully renews its contention that the jury acquitted Ms. Reed on counts one and three, or alternately, there was no manifest necessity for a mistrial as to those counts, and therefore the double jeopardy protections of the federal and state constitutions require that those counts not be retried. So, four people, one third of the jury, has now confirmed one and three not guilty. Will it change anything? Probably not. Because again, who's the king? That's Bev. Bev will dismiss this and say, well, uh, they didn't say it, they didn't write it. There's no reason to do this. Is what I believe will happen. Should they do that? I think they should. I think they should call the jury back in and uh, and figure out, did they actually believe that when they said we can't agree, they were only talking about charge number two. And because of the very strange the first questionnaire were absolutely impossible to understand, and the second one, did they understand what they had to do? Sadly, I don't think Bev will grant it, but if one third of the jury now have contacted the defense, this will also hit the media. How many have to come forward before Bev says, yeah, probably double jeopardy attaches to count one and three, and then you just have the the without malice charge left. And again, if I was the DA's office, I wish she would throw out one and three, and they could say, well, we can't land this one. But one third of the jurors have now all contacted the defense team stating, we agreed she was not guilty on counts one and three. Now it's up to Bev, sadly, because Bev won't budge. I'm pretty sure. Because she's a woman who believes that no one will find out she's a little crooked. In Minecraft, don't sue me. But one third of the jury all agrees that everyone in the room agreed upon not guilty on counts 1 and 3. At least it must raise big concerns for a retrial that Lally couldn't convince them. And with that weak case he had back then, now the defense is ready for him. Now the defense knows all his tricks in the book. He won't find new evidence. The defense will change their strategy if it comes to a retrial. I still believe some Friday night at just 5:45, they will release a press statement that they don't want to retry this. But again, this case is the case that keeps on giving. I just finished a live about Kevin Albert being chucked out of the Canton Police Department. Last week, no, Monday, Proctor was suspended without pay. Last week, 3 witnesses came forward and said, we didn't feel she was guilty on charges 1 and 3, and we didn't feel that we had a way to say it. Now we have one more witness. I do we need 5, 6 witnesses before people are saying this is a little weird. Uh, this this probably should be taken off the table. Maybe at least have a hearing. I don't know. In my opinion, of course they should. In all the smart people who have law degrees, they'll say, "Nah, it's not going to happen," and we'll just they will throw the case out. But it's clearly because the not guilty verdict on the form wasn't clear for them that they should set a mark that she wasn't guilty in charges 1 and 3, and they were hung on charge 2. This case is the worst case I can remember seeing. No justice for John O'Keefe as long as all of this shenanigan goes on. Come on, Bev. Do the right thing. Listen to your jury and take 1 and 3 off the table, even if she most likely won't do it. But 4 witnesses now all agree that they were unanimously agreeing on not guilty on count 1 and 3, which is very good for the defense. But sadly, technically, it probably won't change much